Now I am delivering the lecture on the topic of Order 22, Rule 4 of the Civil Procedure Code and Articles 120 and 121 of the Limitation Act. This topic is relating to substitution of legal representatives of the deceased dependent in the suit. I have already delivered one lecture relating to the introduction of legal provisions for bringing legal heirs, legal representatives of deceased party in the suit. So I request you, please watch that my earlier video, then you will understand this topic clear. So under the Rule 4 of Order 22 of the Civil Procedure Code, it prescribes the procedure in case of death of one of several dependents. I am discussing this topic with reference to one judgment of the Kerala High Court. This judgment is reported, the citation of this judgment is year 1999, reporter All India High Court, page 3841. The parties before the Kerala High Court are Janki versus Sasi. This judgment is given in the revision petition, civil revision petition by the High Court. In brief, the facts of this case is as that there were 4 brothers. One of them died, and that widow of their deceased brother filed a suit for partition against those other 3 brothers of her husband. That widow of that deceased brother, amongst the 4 brothers, she filed a suit for partition as legal heir of her deceased husband. And other, in that suit, there are in total other 3 dependents who are the brothers of her husband, that is, brothers of her husband means husband of the plaintiff. When that suit was pending before the court, that suit was instituted in the year 1997. When that suit was pending, one of the dependent died. One of the dependent died. And that plaintiff, she wished to bring the legal representative of that deceased dependent, that is, dependent number 1 died, and that plaintiff wished to bring the legal representative of that deceased dependent number 1. But the trial court, for that purpose, she filed 2 miscellaneous applications before the trial court. One application is for impleading the legal representatives of that deceased dependent number 1, and another miscellaneous application before the trial court is for the condonation of delay of 30 days for making such application for substitution of legal representative of deceased dependent number 1. She needs to make such application because she has filed that application for the substitution of legal representative after some delay. Therefore, she needs to make another application for the condonation of delay of 30 days. So, that plaintiff, who is a petitioner here, that is Janki, who is a petitioner in this revision petition, she was seeking partition as the legal heir of her deceased husband, and dependents are her husband's brother. And one of that husband's brother, that is dependent number 1, died during the pendency of that suit. But she has made an application for the substitution of his legal representatives, that application was delayed by 30 days. What is the reason she gave for such delay? Because she did not know about the fact of death of that first dependent, because she was not, after the death of her husband, she was not allowed to stay at the suit property, and that her brother-in-laws, who are the dependents, they have obstructed her to live there. Consequently, she was compelled to leave that place of suit property. She went from that place at faraway place, and she started working at that faraway place as a domestic servant with one lady doctor. Therefore, she could not get the information immediately regarding the death of first dependent. In fact, that first dependent was died on 27 November 1997. 27 November 1997. But she came to know about that fact on the 12th February 1998, when that advocate for the first dependent informed the court about the death of his client. So she has made two applications, one for the impleading the legal representative of that deceased dependent one, and another application for the condonation of delay. But the trial court rejected her both application, both miscellaneous application. The reason is given for rejection is that plaintiff has not filed any separate application to set aside the abatement. She did not file any separate petition to set aside the abatement. This is the first reason, and she has not explained the delay of each day. This is the another reason. On this ground, her both petitions were rejected by the trial court, and trial court held that suit has been abated against the first dependent. And because of this order, agreed by this order of the trial court, this plaintiff petitioner came before the High Court by this revision petition. So here, important things to know, that some important dates you may write down it for the understanding of this matter. The date of the death of the first dependent is 27th November 1997. Then, after the death of the dependent, and for making application for the substitution of legal representative of that deceased dependent, the limitation period is provided 90 days. So this is the Limitation Act. In that Limitation Act, there is one schedule, and that schedule means table, and it provides the limitation period for making application also. So for our topic, that in that schedule, in that table, there are various entries which are known as articles. So for our topic, Article 120 is relevant here. What it says: under the Code of Civil Procedure, application to have the legal representative of a deceased plaintiff to made party to them, limitation period is 90 days, and that period of 90 days will start from the date of death of that deceased party. So in our example, the date of the first dependent is 27th November 1997. Then period of 90 days, we have to add that period of 90 days, that is 3 months from this date of 27 November 1997. So after adding the period of 3 months, date will come 27 February 1998, and on that date, until that date, if any application has not been made for the substitution of legal representative, then consequently by the effect of law, by operation of law, that should get abated. So in this case, that should get abated on the date of 27 February 1998. Then Article 121 of the Limitation Act prescribes the period to set aside, application to set aside an abatement. Application to set aside an abatement, and that period is 60 days, 60, and that period will start from the date of abatement. So our date of abatement in our case is 27 February 1998, and from this date of abatement, limitation period for making application for setting aside the abatement is 60 days. Therefore, in our case, that period of 60 days will expire on 27th April 1998. But in our case, however, much before this date, in this case, petitioner plaintiff have made application for impleading legal representative of deceased dependent very much earlier, that is on 23rd March 1998. Means in fact, her application for impleading legal representative of deceased dependent, it was very well within the limitation period as per the Article 121, because limitation period is 60 days from the date of abatement, and in our case date of abatement is 27 February 1998, and that period of 60 days will expire on 27 April 1998, but she has made an application on 23rd March 1998. Nevertheless, the trial court has rejected her petitions on the ground that she has not made a separate application to set aside the abatement, because she has made only two applications, one for impediment of the legal representative and another was condonation of delay. So when the matter came before this High Court in revision petition, the advocate for the petitioner plaintiff contended that the petition for impeding was filed on 23rd March 1998, that is within 60 days from the 27th February 1998, that is the date of abatement. Therefore, trial court should have considered the application as a petition to set aside the abatement also. So it was the contention of the petitioner plaintiff that before the High Court, the court should have considered the application made by the petitioner, application to set aside abatement also. But in fact, that petitioner plaintiff has not made a separate application to set aside the abatement. But it was the contention of the advocate on behalf of the petitioner that court should have considered that her application for the impediment and for condonation of delay as an application to set aside the abatement also. For that purpose, that advocate for the petitioner relied upon two decisions of High Court. One decision, it is the decision of one judgment, it is the judgment of Punjab and Haryana High Court in the case of Bachan Ram versus Gram Panchayat, Jonda, and it is reported in All India Reporter, year 1971, Punjab and Haryana, page 243. So in this reported case, the judge of the High Court took the view that if the petition for impeding legal representative had been made within the period of 60 days provided under Article 121 of the Limitation Act, then that application should have been treated by the court, trial court, as an application for setting aside of the abatement. So what the High Court says, when the application has been made for impeding legal representative, and when that application has been made within the period of 60 days from the date of abatement, then that application itself should have been treated as application for setting aside the abatement. That advocate for petitioner also relied upon another judgment of the High Court, Kerala High Court. The parties in that case was Kunni Kayyamma versus Union of India, and that judgment is reported in All India Reporter, year 1984, Kerala, page 184. It was held in this reported case by the High Court, if from the facts and circumstances of the case there is a sufficient cause for the delay in seeking substitution of legal representative of deceased party, then the court will be justified in granting the relief, ignoring the fact that the fact that affidavit neither mention the cause for delay nor prayed for setting aside the abatement. So this High Court says ignore this fact that affidavit in support of the application has not mentioned the cause for delay, or there is no separate application for setting aside the abatement. So it was the observation of the High Court that the prayer to set aside abatement should be treated as being implicit. That is, implicit means it is a part of it. The prayer to set aside abatement should be treated as being implicit in the application for impleading the legal representative. So there is no necessity to make a separate application for setting aside the abatement. And this view of the Kerala High Court has been upheld by the Delhi High Court in one case, that is Delhi Development Authority versus Raghunath, and that case was reported in All India Reported, year 1973, Delhi, page 262. So that advocate for the petitioner plaintiff before the High Court has relied upon all these reported judgments. So in our present case also, the application for impleading the legal heirs has been filed within the 60 days from the date of abatement. So it is within limitation. So Article 120 of the Limitation Act prescribed period of 90 days, which starts from the date of death, for making the application for impleading the legal representative, and Article 121 provides for the period of 60 days for filing an application for setting as an abatement, and that period of 60 days is to be counted from the date of abatement. If legal representatives are not impleaded within 90 days from the date of the party, then suit will abate, and an application for setting aside abatement should be filed within 60 days from date of abatement, that is after expiry of that initial period of 90 days. So in our present case, the first dependent died on 27th November 1997. So after considering the period of 90 days, the date of abatement is 27 February 1998. So in our case, the petition for impleading legal representative of deceased dependent was filed on 23rd March 1998, which is within the period prescribed under Article 121 to file an application for setting aside abatement. Therefore, taking into consideration all these facts, and this suit is also one for partition. It was the view of the Honorable Judge of this Kerala High Court that trial court should have allowed the petitions. So this is a suit for partition in which there were 3 dependents. And who are those dependents? Those dependents are the brothers of the deceased husband of the plaintiff. And if we consider the provision of Rule 4, procedure in case of death of one of several dependents, what it says, when one of more dependents dies and right to sue does not survive against the surviving dependents alone. When right to sue does not survive against the surviving dependents alone, it means that there were 3 dependents brother, one of them died, so 2 brothers remain, and therefore right to sue for partition does not survive merely only against those surviving 2 dependents. Therefore, there is a necessity to bring on record the legal representative of that first dependent, who is also brother of that other 2 dependents, because this is a suit for partition. So, with the help of this reported judgment, we have considered the provision of Article 120 and 121 of the Limitation Act, and also Order 22 Rule 4 of the Civil Procedure Code. Thank you.